Welcome to the AI4EU Cafe for live presentations around AI. The speaker is today Olga Hamama. She is from V29 Legal, Duve, Hamama, Rechtsanwäelte from Germany. Hi, Olga. Nice to have you here. I'm very happy to welcome you for the second time, and this time the talk will be about Artificial Intelligence Act, a closer look at the ECs Proposal and its consequences. My name is Carmen McWilliams, and I'm the moderator and organizer. I'm the director of the company, Grassroots Arts, and partner in European AI4EU project. And again, in the beginning, our small regulations. Please take notice that the session will be recorded. No confidential information shall be shared in this cafe session. In this cafe, the speaker expresses her personal view and opinion. This is not necessarily the official AI4EU project opinion. So what's this cafe about? It's an online forum to gain insight into the European AI scene, and participants get the chance to share knowledge and experiences and meet stakeholders from various areas of AI research and application. In short, you can now network, and if you have questions to the speaker, please tell them today in the cafe, write them down on the right side in the control panel, and I will read these questions to the speaker afterwards. And or you can also, after the live show, contact the speaker if you have more direct questions. So this is interactive, and I welcome everybody here in the cafe, especially all the participants joining us today. Still some are coming in to the cafe. It is great you're here. Here in Cologne, where I am, it's a rainy day, so I hope you're all coming. So now we come to the main highlight of the cafe. That's, of course, our speaker, Olga. And I introduce you. Olga Hamama is an international dispute resolution lawyer with a specific focus on climate change and technology-related matters. Olga acts as an arbitrator, co-counsel, and is also advising clients on regulatory and policy-related matters regarding artificial intelligence. Olga is a member of the Silicon Valley Arbitration and Mediation Center and is AI legal at the German AI Association. So, most important, welcome again, Olga, and you will now get the presentation floor. I give you the presenter role, and then you can introduce yourself, and we are looking forward to hear from you more.
Thank you very much, Carmen. Thank you very much for the kind invitation and the kind introduction, and huge compliments to the project and to the work you do and been doing since almost 2 years already. It's a pleasure to be here. Thank you very much for everyone for tuning in live, and for all those who will be watching the recording afterwards on YouTube. It's my second time in the AI4EU Cafe, and it's a huge pleasure. The first time I've been talking about the regulatory developments related to AI all over the world and in Europe in specific. And now, just a couple of months later, what we've seen is a proposal of the European Commission for the very first regulatory framework for AI worldwide, actually, and this is going to be the topic of today's presentation. So today I'd like to talk to you about Artificial Intelligence Act and provide you with a first overview of the ECs proposal. Based on the experience from the previous session, and we had a very lively debate and a lot of questions coming in, which I was not able to answer during the time we have, I decided to give you first a presentation which will take for about 30 minutes and reserve extra more time for your questions afterwards. Because I completely understand that depending on the sector you are coming from, or the industry you are coming in, or your background, whether it would be a scientific or practical one, the questions might vary, and the meaning and consequences of this proposal for the EU of the European Commission might vary as well. So I will be happy to hear questions afterwards, but as Carmen kindly suggested, you can feel free to type them as I go, as I present, and we will get to them after. So Carmen has already kindly introduced myself. My name is Olga Hamama. I'm based in also rainy Frankfurt today. So what are we going to talk about? First of all, I'd like to map the scene and introduce you to the broadest topics around the proposal to map the scope of the AI Act. I would then like to answer the question, which AI applications are covered by the AI Act? Which risk category does your, in that case, AI application could fall under? And how the companies that are developing, using or deploying AI applications at the moment already can ensure AI governance and compliance. So let's dive in and start with the first topic, the scope of the AI Act. So first of all, I'd like to take back you, for those of you who listened to my first presentations, to 2 points I already raised during the last presentation. The regulatory trends around AI have been picking up throughout a couple of recent years, actually, and not only within the European Union. We've seen proposals in the US and in China. We've seen also worldwide proliferation, if I may refer this way, to the development of AI principles and call for setting standards for ethical and trustworthy AI. And those calls came inter alia even from the players from the market, also in the context of specific AI applications, one of the examples being IBM, for example, around surveillance and usage of AI in the public spaces. So overall, we've seen 2 trends. So increasing self-regulations, which has been imposed by corporations upon themselves, and emerging public regulation, and also calls coming from industry towards governments to introduce regulatory frameworks. And indeed, EU was among those creating an initiative and paving the way on the way to a legal framework for AI. This is another slide I've shared with you during the last presentation already, which mapped the roadmap, the way EU was developing its strategy and its regulatory framework. So last time we've seen the EU, we've been talking basically and discussing with each other this topic. We've seen the presentation of the white paper on AI by the European Commission. The European Commission then launched a consultation process with players from private sectors, but also from representatives of various associations and governments on national levels. Overall, within this whole process, EU gathered more than 1,500 opinions from various stakeholders and players within the European market. In October 2020, we've seen also a proposal from the European Parliament with regards to the AI framework. And what happened on 21st of April 2021, almost, well, it is already more than 1 month ago, we've seen the ECs proposal for AI regulation. As I mentioned, it is the very first proposal for the legal AI framework worldwide. I mean, we've seen, and in various countries, some types of regulations addressing AI applications exist already. Many of you would know, for example, GDPR, Data Protection Directive. Of course, it also applies in certain aspects to AI applications, but this proposal is a proposal which is, it's not targeting a specific segment, it's a specific market sector. It addresses AI applications in general. So the proposal, which has been published at the end of April, contains, well, basically 3 main elements. First of them is the legal framework for AI, which we are going to talk about today. So this is a new regulation which is going to be applicable directly and also in the same way across all main member states of the European Union. And it is also based what the European Commission is referring to as the future-proof definition of AI. So we are going to have a closer look into it in a couple of minutes. I will be referring to the regulation as the Artificial Intelligence Act, AI Act, or AI regulation later on. In addition, we've seen a proposal for a coordinated plan with member states, which is a proposal aiming at guaranteeing the safety and fundamental rights of people and businesses within the European Union, while strengthening the AI uptake, investment and innovation across Europe. And it is also important to say that the main goal of the European Commission is actually to foster and enhance and support innovation and investment in AI across Europe, while guaranteeing the fundamental rights which are also can be found in the European Human Rights Charter. So this is basically the framework, but the main goal again is a positive one, which is aimed at development and innovation and strengthening of Europe on a global scale when it comes to development of AI applications. In addition, last but not least, we've seen also a proposal for of new rules on machinery. So this legislative proposal is supposed to complement the approach, but by adopting safety rules to increase users' trust in the new versatile generation of products. So here we are talking about machinery, which contains AI application as one of the elements, right, which is based on AI applications or comprises AI applications. I'm not going to touch upon this initiative in detail. Again, today the focus is on the Artificial Intelligence Act as such. So let's touch upon the 3 main questions when it comes to the scope of applications, being where is it going to be applicable, to whom is it going to be applicable, and when is it going to become a binding piece of legislation. So starting with where. First of all, it is a European directive, and this legal framework will apply firstly to both public and private actors inside and outside of the European Union. While inside is natural, right? It's also important to understand that even players outside of the European Union might be affected by the directive. Why and how? This will be the case if AI systems created, for example, developed by third parties coming from third countries is going to be placed on the European market, or in case its usage, even if it happens outside of the EU, is going to affect people located within the European Union. So this is something which is important to understand. Again, while it is a local regulation as such, similarly to GDPR, it might have, well, it will have impact and will set standards worldwide, again, as long as applications developed in third countries will be placed on the European market or will have effect on the European citizens. To whom is this regulation going to apply? It concerns both providers, developers of AI systems, as well as users of AI systems. It doesn't apply to private, non-professional users of AI applications. And now coming to the most exciting question for many, when is this proposal going to become binding? What's happening now? So it is a proposal, right? What we are looking, or what we will see happening in the next months or maybe even years, is the process which is referred to as legislative negotiations. So we will see negotiations happening on the European level, within the European Parliament, but also on the national level. The consultation period it has actually started. The European Commission is accepting I think consultation papers by the end of June, if I'm not mistaken, but might also consider others at a later periods of time. So what can happen theoretically? Of course, the proposal can be amended based on this consultation, based on the proposals and recommendations which are going to happen within this period of time. My personal assessment is that we are not going to see any any big changes in terms of structure or in terms of strategy, how the proposal goes around different types and categorizations of AI applications, but we might see some changes nonetheless. So it is expected that having undergone this process, we will see the final piece of legislation entering into force in 2 years period of time. So I'm seeing right now, so for obviously 2021 plus 2 would be 2023. Sorry, it's still 2021 on my slide. Once it enters into force, within 3 months of entry into force, we will see that certain bodies will be established on the European and national level, which will be responsible for notifications, auditing, and some aspects of governance which are infringed in the proposal. And then the so-called implementation period of 2 years will start as well. So it means once the regulation enters into force, those applications which will be on the market at the time will have 2 period of time, right, to adopt and comply with the regulation. So having considered the scope and these aspects, let's dive in now in some of the details. So what type of AI applications are going to be covered by the AI Act, again, as it stands, as the proposal stands at the moment, right? So I've mentioned briefly already the definition. It is from lawyers' perspective, especially, I think it is a very important step that the proposal contains an AI definition. It is already being subject to some of the criticism from various stakeholders. I would like to give you, the background why it is the case. So if you are going to have a look into the definition, it's in Article 3 of the proposal. It is a very broad definition. It refers to various types of technologies and, techniques and approaches, and they are listed. And again, it's also an exemplary listing in Annex 1 to the proposal. Annex 1 is titled Artificial Intelligence Techniques and Approaches. So you will see that a lot of different technologies and techniques are mentioned there, but nonetheless, the focus of the definition is rather on the outcome and usage of these technologies. And I would completely agree with everyone that it's a very generic, very broad definition. While many see this point as a negative one and criticize it, I think the rationale behind is the well understood point by the European Commission that artificial intelligence is developing so fast that a rigid, a static definition would not be timely. By the time this proposal enters into force and becomes binding, again, we might be looking at 4 years of time. In these 4 years of time, we might see new technologies and techniques being developed and applied on the market. This is the main reason why this definition is so generic and why the European Commission opted for this one and on the focus of its usage and output rather than a clear definition of the technology as such. Well, we'll see. Again, it is one of the topics which is being discussed and criticized by some. We will see whether we are going to experience any changes in this context. Another important aspect of the regulation is that the European Commission adopted a so-called risk-based approach. European Commission decided to define various risk categories when it comes to AI applications, and depending on the risk category an AI application is falling under, certain consequences are going to apply. So let's have a look what type of risk categories are there. So again, I mentioned that the regulation has adopted a so-called differentiating metrics with various level of requirements resulting from this risk level. It is also important to mention at this point that in European Commission's view, most of the applications which are on the markets at the moment are going to fall under the category of minimal or limited risk, and only a small fragment of AI applications are going to fall under the categories of so-called high risk or unacceptable risk applications. So let's have a look. What do those risk categories mean in specific? So on the basically highest level of risk, we see so-called unacceptable risk applications. Those are AI systems which are clearly considered to be a threat to safety, livelihoods, and rights of people, and those AI applications will be simply banned. So what type of applications can we imagine here? For example, one of them is clearly social scoring. I mean, we've heard from so-called social profiling in the context of China. This is something the European Commission decided to clearly say no to. This is something which is incompatible with the fundamental rights and democratic principles which are the foundations of the European Union and European Human Rights Charter. In other type of applications which are going to be banned as well are, for example, systems or applications that can manipulate human behavior to circumvent users' free will. In this context, the European Commission aims at protecting especially most vulnerable groups, like, for example, children. So let's jump to the second category. Second category, when we start with the highest risk level, are so-called high-risk applications. High-risk applications are also defined in the proposal, and we have basically 2 steps when it comes to definition of AI applications or classification of AI applications as high-risk applications. First of all, the proposal comprises so-called classification criteria. So this is a general description, again, based on the usage and outcome of the AI applications, that describes what type of applications are going to be defined as high risks. Applications. At the same time, the proposal contains in Annex 3, if I'm not mistaken, we see it here on the screen, yes, Annex 3 of the proposal, a list of applications which are being defined as high-risk applications. So once this regulation enters into force, if it's not going to be altered as it stands right now, what's going to happen? So first of all, the requirements which are consequences of categorization as high-risk applications will apply only to those high-risk applications that have been identified in Annex 3. The European Commission has, however, reserved the right to review this list and amend this list on an annual basis. In my view, this is the bit of legislation where we will see probably a lot of comments, inputs, and this will be also is one of the core pieces of the proposal, because of course for those who are going to qualify, those applications that are going to qualify as high-risk applications, you will see in a minute stricter obligations and consequences will apply. So let's have a brief look at the examples. So what type of applications have been already included into Annex 3? So here we are talking about AI applications that are critical to infrastructure, transport, talking about autonomous driving, for example, and could put life and health of citizens at risk. Here we will see the category of educational or vocational training that may determine the access to education and professional course of someone's life. For example, scoring of the exams. I'm sure that some of you heard about scandal basically that happened in the UK in this context. Also safety components of products, for example, AI applications in robot-assisted surgery have been defined as high-risk applications. Employment, workers management, and access to employment. So we know that a lot of AI applications are being applied already within the context of human resources. It is one of the controversial points because the discussion now evolves around the question whether these AI applications are indeed so intrusive or, really bring the risk category which justifies putting them on this list. We'll see how the situation is going to evolve here. My personal take is that, like giving the time we live in and also all the discussions, and not only discussions, but unfortunately also events that happened stemming from bias, all the discussion around bias and discriminations. Personally, I don't think that this application will disappear from the list, but let's see. Otherwise, we see also application in essential private and public services, like, for example, credit scoring, which might deny citizens to obtain the opportunity to obtain a loan, for example. So this bit will, or this specific example will, of course, affect financial sector, financial services. We also see applications which are applied by law enforcement authorities, administration of justice, democratic processes, but which also play a role when it comes to migration, asylum, border control management. So let's now have a look at the consequences and mandatory requirements which will apply to those applications. So as I mentioned previously, all high-risk AI systems will be subject to strict obligations. First of all, before they can be put on the market, a so-called self-assessment will be required. In some instances, even supervision from third authorities will be required as well. Once such applications pass basically the tests, they can enter the market. They will be also included into the European-wide list of high-risk applications. They will receive a so-called CE marking, that those are high-risk applications, but that comply with the requirements of the European Commission. But they will still be subject to monitoring, auditing, and reporting obligations thereafter. So just to have a look at some examples here. So what are we talking about? First of all, the requirements, for example, of adequate risk assessment and mitigation systems, logging activities, requirements to maintain and assure high quality data sets, detailed documentation, which will be required here as well, and the requirement to provide all the necessary information on system, its purpose for authorities to assess compliance, again depending on applications, sometimes even before they are put on the market, but then mostly for monitoring, auditing and reporting thereafter. We also see the requirement of human oversight. Maybe some of you remember from the last presentation, it's one of the core elements of the European approach, a so-called human-centered approach, that human still has to be basically in the loop or on top of the developments and oversee the application. And also we see the requirements for high level of robustness, security and accuracy of the system. To mention one specific examples, I also want to briefly draw your attention to remote biometric identification systems. So, for example, in this context, live use in publicly accessible spaces for law enforcement purposes is prohibited in the European Union in principle. There are some very narrow, strictly defined and regulated exemptions here in this context. For example, if it will be used in order to search a missing child, to prevent child abuse, or, for example, terrorist threats. But in other cases, such use, well, in this specific, even when it comes to these exemptions, again, such use will be subject to strict authorization by judicial or other independent bodies. In other cases, these applications might qualify as high-risk applications. So here is just a so-called compliance assessment cycle. This is something you can also see on the website of the European Commission. So this is basically a graphical presentation of the cycle as I have briefly discussed it. So once the AI system is being developed, it has to undergo a conformity assessment and comply with AI requirements. For some systems, again, appropriate bodies will have to be notified. Once this conformity assessment and compliance assessment has been completed, a registration of standalone AI system will happen in the so-called European database of high-risk applications. Afterwards, a declaration of conformity will be signed and AI system will bear this CE marking. The system can be placed on the market then and have to undergo constant monitoring. In case of some incidents, changes, alteration to the system, the process would have to be undergone from the very beginning. So then we have a category which is referred to as limited risk applications. For those applications, specific transparency obligations are going to apply. So what are we talking about here? Here we are talking about systems that interact with humans, are used to detect emotions or determine association with specific social categories based on biometric data, or generate or manipulate content. So, sorry, while it might be, apologies, while it might be difficult sometimes to imagine what is meant by this type of definition, excuse me, here, for example, we are talking about chatbots, for example, something which I think by now is in a way a standard offering that comes, for example, with many websites. And this is something which really can affect many of us. or at least developers of those systems, because these will have to be marked as those. So even if someone is using a chatbot, then the end user would have to be notified and to understand that any suggestions are AI driven and are coming from AI application and not from human being. And when it comes to deep fakes, for example, those will have to be marked as such. So we've seen, well, you know, rise of deep fakes or risks arising from those, especially during the election campaigns. So this is also a very strong reaction of the European Commission in this regard. And finally, there is a layer of AI applications, again, which in European Commission's view belong to the majority of applications on the market right now. They are not going to be subject to any restrictions or any regulations. However, the European Commission encourages in this context for developers and users of these AI systems to create and adopt so-called voluntary code of conduct. Again, in order to fulfill the requirements of trustworthy AI, in European Commission's view, this is also one of the ways how trust in those applications can grow on the side of customers and users of those AI systems. So last but not least, let's have a short look at the question, how can we ensure AI governance and compliance at the moment? So if one looks at the AI Act, at the proposal only, first, it is important to to make a so-called inventory, I would say, of AI applications that are being deployed at the moment by a respective company. You know, for some it might be one, for some those might be many. Then it would be important to understand whether those type of, well, first of all, those type of applications can be qualified as AI in view of the definition provided in the proposal in the first place. If that is the case, then it is important to assess, you know, what type of risk categories are those AI applications going to fall under, because as we've seen, depending on the risk category, different consequences and standards will apply. Once this is the case, then it's important to check whether those requirements are complied with, and ensure that design, development and quality management systems are in compliance with the requirements of the Act. Then the so-called conformity assessment is going to take place. Again, once the regulation enters into force as it stands right now, this would be the timing to obtain a so-called conformity declaration to enter the EU database and launch the product when it comes to high-risk applications. And afterwards, monitoring is important as well. It is important to monitor whether you know, there are some disruptions or changes to the systems. If that's the case for high-risk applications, the process will have to be you know, undergone from the very beginning until the end. And also once the regulation enters into force, also reporting and auditing requirements will apply. So, you know, the questions a lot of practitioners are asking at the moment are, of course, you know, is it important to undergo that assessment and to do all the thinking already now? Now we are talking about proposal only. You've heard it might change. Again, I don't think it will. We will see a lot of changes, but still we can see some. In my view, and of course it is a very personal view, first of all, we've seen that the tendency is towards regulations, not only within the European Union, but worldwide. The European Commission is a trailblazer in this regard, and this regulation provides at least you know, there are some critical points and there are a lot of questions marked, but still a clear, structured framework for assessment and development of AI, which might also provide certainty rather than uncertainty to a lot of developers and users of AI systems. So what can be done if someone is looking into those questions? Those proposals didn't change really from the last time I've been speaking to this audience. So first of all, of course, there is a possibility to obtain classical advice from the experts. A lot of big corporations and a lot of startups as well also opted for the option to establish so-called ethics boards. So we'll see, it is still a viable solution. We will see whether it's going to change or not, but it's definitely a possibility, you know, to have an advisory body overseeing these developments on a continuous basis for specific companies, specific applications. There are many suggestions to integrate transparency by design. So one could now also integrate to the extent possible within the technology in the design process and consider the requirements imposed by this proposal. Deployment of XI, explainable AI, might be one of the solutions, or usage of guidelines or tools for self-assessment, which have been introduced in the recent years as well. Altai, for example, which has been introduced by the high-level expert group of the European Commission, is one of them. So this takes me to the end of my monologue and my presentation. Thank you very much for your patience. Thank you very much for listening to me. I would now be happy to take any questions we have. Carmen, I think you have a, you see the chat.
Yes, I will now go over. First, I want to thank you in the name of everybody here. This was a great presentation, and I will right away switch to the questions because we do have many as expected. And I thank everybody for sending us these questions. And I start with the first one. From Francesco Medeiros. You said that the AI Act does not apply to private, non-professional users. Could you point out where exactly the Act excludes these?
I mean, this is if you want to have, like, you know, if you want to have an exact citation, then please share your email address with me. You see my email address, and I will be happy to see, you know, to pin you the point where it's being said. It must be either in the preamble or in the scope, you know, definition of the application in the body, in the text of the proposal itself. But I don't remember the page from top of my head right now. So please drop me an email. I'll be happy to pick up on that question.
As a joke, Olga is not a robot or AI. She's human like me.
I am.
So as a human. So also secondly, as Olga already said, there is an email. You see right away Olga's email. There is also other questions like, can I have the presentation? Will you share it? All this, please ask Olga directly. There is not a public sharing presentation place. So there is an email. So please, if you have a question directly to Olga, send it to her. Now go further. Guy, hi Guy Melis, with reference to section 3, also number 3, high-risk applications. The EU itself is responsible for migration, asylum, and border control through the applications of visa, entry, exit, etc. Will an independent body be established to audit the European Union itself?
Well, first of all, you know, you have to differentiate while the responsibility for the governance, right, of those issues within the European Union. Here we are talking about the AI application and usage of those AI applications within this context. What does it mean? It means that, you know, I have, well, no precise idea, but I can imagine that European Commission or European Union is not developing any technology for monitoring, for example, of migration developments by itself, but this is rather developed by a company, whether seated in the EU or outside of the EU. So if this technology is to be deployed on the European market, and
we are losing you, Olga. Let's wait. I hope she comes back. I hope. I think there's a bandwidth, Olga, a bandwidth problem. Hello? Let's wait. I think she comes back. So we hope Olga comes back. I hope you hear me still. I think yes. We have some more questions. If not, as I say, you have Olga's email in the picture, and you're welcome to call and to write her. Best is, of course, sending an email. That's always the best. I think we're having an issue with So if Olga cannot come back, I don't see her coming back. We wait a little bit. Please be patient. And maybe she comes back. Now we're also losing her PowerPoint. I will try to take back my PowerPoint. I will also really want to invite you for next Monday. That's my last AI4EU Cafe for the summer season, and it will be on AI ethics and human rights, designing a better world, and it will be by Bernd Kastenstahl. Hi, Olga. Hi, Olga. Hello. Can you hear us? Can you hear me, Olga?
now I can hear you. Sorry, Carmen, can you hear me? For some reason, I assume it's mine internet connection. Apologies for that, guys. But can you hear me now?
Let's take the next question. As we had discussed about the border, the border, European Union, the border, I think we are quite there. Can I ask another question?
Sure, sure.
This is from Faiz Ikram Mullah. Hi, which entity is accountable for monitoring the validation of the CE marking once out in the field, in the wild? What do you think?
So those entities will be established. So we'll see that the responsibility in that regard will be with the member states. The entities within the member states will be established. We will see, those might be entities which will not be established, let's say, from scratch, but specific departments or responsible departments will be established within existing bodies. But this will happen on the national level within the member states.
Yes, great. So then, thank you. Another question, and it's from Zachariah, sometimes Zachary Goldberg. Thank you, Olga. The proposal for regulation is very welcome. Do you expect more detailed guidance concerning what it means precisely by adequate assessment, appropriate oversight, detailed documentation, etc.?
Absolutely. So I think this is something we can expect as well. So that it's basically one of the questions which targets a lot of questions surrounding the proposal at the moment, starting with the definition already, right? One of the criticisms is even that it's too generic. What does it mean exactly? But I think it is a very typical feature of legislation in general. It has to be flexible in a way in order to be interpreted, right? So we will of course see then use cases, we might see differences or differences, like again depending on applications. We've seen, for example, a lot of question marks when it came to application of GDPR to AI applications. We've seen guidance, for example, being introduced within the UK in this specific regards, because people were asking, so what does it mean? What does it mean? What does appropriate documentation, like how shall we transfer those requirements into practice? So I do think this is something where discussions are going to take place within the next periods of time. We might see some amendments there. Again, depends. I think in general the fact that the legal framework is flexible in a way is a positive one, but of course as a user one always asks him or herself, what does it mean for me? What do I have to do precisely in order to comply with the regulations, with this regulation? And this is something we will have to develop and work on, and we will see. It can be already like reading the documents accompanying the regulation. They help a great deal to answer some of the questions, and I think we will see more explanations coming in there.
Yes, thank you. And here comes Audi Schenken. Do these regulations apply to AI systems developed by EU companies or used by EU companies? Question. Is it not going to disadvantage EU companies that will have to comply with these regulations compared to US or other foreign companies?
Well, I think yes, as previously mentioned, the geographical scope of applications is such that it's going to apply to the AI applications which are being developed and used within the EU, even for those that are developed outside of the EU but which are used on the European territory, or which affect citizens of the European Union. So this is the scope. It's indeed broader than the European Union as such. Are AI companies, European AI-based AI companies, going to be disadvantaged? I think the focus or the direction the European Commission and the European Union is looking into when it comes to developing a framework for AI is, again, the guarantee of the fundamental rights within the European Union. What does it mean? It means saying categorically no, for example, to social profiling. We know that it is being developed and used by the Chinese government, but the European Commission decided that it is a no-go in view and in light of the fundamental rights of the European Union. So I think, in fact, what we can compare maybe the aim or the idea behind of setting of such standards in a very simplified way, in a way, for example, if you would think of products that are developed within the EU, or for example ecological products that are developed within the EU, once we see this stamp that it is, it's been certified as a product which responds to the requirements within the European Union, we also, well, I cannot speak for everyone, but the idea and the perception on the market is that it also transfers a certain degree of trust in that product. So I think this is the idea also when it comes to AI applications as well. So we will see European quality high-level application, European quality applications that rise up to those standards, and comply with the requirements, again, fundament of which are fundamental human rights of the European Union. Commission has stressed the potential of the technology and its absolute aim to, again, foster innovation and support funding into the sector. At the same time, well, also because the technology is based or is learning based on the data coming from us humans, and we all know we are not, faultless by far. There is danger coming in certain aspects when it comes to AI applications, and the attempt is to basically to control or ban those risks coming from those applications. So
yes.
It depends on the view, right? How you see it. You can say that yes, unfortunately, development of social profiling systems will not be, allowed within the European Union, but then a company should or can move to China, for example.
Yes, and offer it from there. And yes, we are coming slowly as always. You have more questions, everybody, than we have time, but we are coming here to one more. Shiva Garimani. Hi, Shiva. Thanks for the presentation. So, thank you for your compliment. Do you think this might become a new GDPR, where there's a big hype in the beginning and then losing of everyone's interest and attention?
Yeah. It depends. So it is indeed, the regulation, the approach that has been adopted by the European Commission is very similar to the approach which has been, which we've seen when it came to the GDPR. First of all, we see not like sectoral approach. The European Commission decided to have a to introduce a regulation that is going to apply to all types of AI regulations, independent of the sector. And also, as far as geographical scope is concerned, we see a lot of similarities there as well. I absolutely agree with you that we will have to see how the regulation is actually going to be enforced, how the authorities are going to go around it. Since some applications again are already being banned like from the very beginning, or will have to go through this assessment process before they enter the market, even if it's self-assessment, and then have to be registered. I do think that the European Commission introduced like very strong mechanisms in its proposals that definitely provides foundation for a very effective monitoring of the enforcement of the regulations. But at the end of the day, yes, we will have to see, and as I mentioned, we will have certain bodies developed on the national levels. So even if the regulation is going to apply in the European Union, we will see how those, maybe approaches of the national authorities will differ. We will see how effective and up to speed they will be with the enforcement.
Yes, thank you. And now really the final, and I know there are more, but as we said before, please send an email if you would like. So really the last for this show is Regine Paul. Hi, Regine. Thanks for the great and informative talk, Olga. I am a researcher working on risk-based forms of regulation. I've written about food safety and flood risk assessment in Europe. Do you know whether EC's risk-based approach to AI builds on experiences in other sectors, such as food safety controls or terrorism finance, etc.?
Categories. So this I will not be honestly speaking. I don't know whether any examples from those specific examples you mentioned have been considered. I know that definitely, a lot of discussions took place with regards to risk-based approaches also, and, experiences that were inferred from GDPR, for example, or from different applications in that context. I know that, for example, German Commission for Ethics has also advised to have to adopt a so-called risk-based approach, because the AI applications differ, and it would not be fair to everyone, to impose same type of restrictions or same type of obligations on everyone. So whether this approach will be adopted in general has been subject to discussions. Again, cannot tell you whether those specific examples you mentioned have been considered upon, but I'm sure that if you would consult, any documents that led to the white paper or any publications or presentations, there are some by those who were involved in the drafting process. I think it might be very informative from the research point of view and for your purposes. And thank you very much for the compliment.
So I also once more give you a compliment. Thank you. You are great presenter and great answerer of difficult questions. And we're coming now to the end. I thank you again. And I think it shows that this topic is very, very interesting to everybody. Last question from my side. How would you like to do it with the slides, as more and more people are asking the same question? Shall they send you an email, as I said before? Is that good?
Absolutely. If there is an easier way, I'm happy to share the slides with you, but I think you'd prefer it, right? That's why that I'm sending slides directly.
Yeah, so I forward, for some reason, I only send it to me, the question, then send me an email. It's a little bit GDPR good that you are personally behind it. We are not just spreading the information widely in space, and it's about networking, and therefore if you have interest, please identify yourself, write to me or write to Olga, and then you will get the slides and also the recording. As always, I will send it now to Olga. She decides if she wants to have it published or not. If yes, it will be in the AI4EU video channels. That's up to Olga, to each time to the speaker. And thank you, everybody, and have a nice day, and see you soon, hopefully. Everybody back in the cafe. Bye-bye.
Thank you, Carmen. Thank you, everyone.